On April 10, 2019, I submitted writ of habeas corpus pursuant to Title 28 U.S.C. 2254 to the United States District Court of Eastern Washington, alleging the violation of constitutional rights pertaining from the absence of an indictment by a grand jury per Clause 1 of Amendment 5. That order was summarily dismissed by the United States District Court. I followed up with a response indicating that it was the district court's responsibility to act first because they have original jurisdiction in accordance to Title 28 U.S.C. 1331 and 1343. The court did again summarily dismiss, citing the need to exhaust state remedies. I followed up with an additional response stating that the court has a duty to act, of which violation would be a violation of a statutory obligation, which would then result in the violation of the rights of the individual that's entitled to the fruits of the obligation. That would be myself. The court again dismissed, citing exhaustion of state remedies. So then I appealed to the United States Court of Appeals for the Ninth Circuit. This was a supplement that was added to that particular appeal letter. Petitioner respectfully submits to the court for consideration this supplement to the notice of appeal letter. Petitioner has submitted a writ of habeas corpus pursuant to Title 28 U.S.C. 2254. This writ of habeas corpus is an original civil action challenging the constitutionality of Article 1, Section 26 of Washington State Constitution, which is directly and facially unconstitutional, as well as deprives petitioner of equal rights and equal protection under the law as a United States citizen in violation of the United States Constitution and Title 42 U.S.C. 1981. Therefore, this matter is clearly controlled under the provisions of Title 28 U.S.C. 1343 as a civil rights violation, and the district court has original jurisdiction as prescribed by law. This duty for the district court to rule on the merits of the petition first and before any other court, including the courts of Washington State, is further assigned by Title 28 U.S.C. 1331 and Title 28 U.S.C. 2254 B1bii 5F. As a result, the district court had a duty to act, and its failure to do so was a breach of a statutory obligation imposed by positive law. Black's Law Dictionary defines misconduct as a dereliction of duty, unlawful, dishonest, or improper behavior, especially by one in a position of authority or trust. The definition of dereliction of duty is a deliberate or accidental failure to do what should be done, especially part of one's job. There is no denying the district court judge derelicts his duty imposed by statute as evidenced by his dismissal of the petition alone. As a result, official misconduct occurred, resulting in improper and illegal ruling. In accordance with Civil Rule 60B, petitioner has up to 1 year to appeal the case of intrinsic or extrinsic fraud, misrepresentation, or other misconduct. Let this letter serve as notice that the petitioner, Tana M. Downing, case number 4:19-CV-05055-TOR, Downing versus State of Washington, hereby appeals to the United States Circuit Court of Appeals for the Ninth Circuit from the final judgment entered into the case on May 14, 2019. The respondent is properly identified as the State of Washington, as the State of Washington is civilly accountable for the criminal misconduct of its agents, in this case, Benton County Superior Court Judge Alexander Carl Ekstrom and Benton County Special Prosecutor Diana Nicole Ruff, among others. In consideration of this appeal, let it be known that the ruling summarily dismissing the petition derives from a criminal act perpetrated by District Court Judge Thomas O. Rice. As a result, as the record will reflect, and in Addendum 1 and 2 of the writ of habeas corpus, specific allegations of conspiracy to obstruct justice were raised against the trial judge, Benton County Superior Court Judge Carl Alexander Ekstrom, by and between Prosecutor Diane Nicole Ruff. Their criminal acts are not only archived during the trial, but were also witnessed as well as acknowledged by the perpetrators themselves during the trial. However, they claim that the State of Washington provides them with immunity from their criminal acts. Their mens rea is not negated by their ignorance of the law. They chose to proceed despite awareness of the criminal conditions, even after acknowledging the crimes, yet trusting to find impunity in their absolute immunity. However, absolute immunity only covers civil liability and not criminal liability. In accordance with Title 42 U.S.C. 1985b, if two or more persons conspire for the purpose of impeding, hindering, obstructing, or defeating in any manner the due course of justice in any state with the intent to deny any citizen of equal protection of laws, commits the crime of conspiracy to obstruct justice. Petitioner provided specific sources of evidence to confirm these allegations, to which the district court judge chose to ignore, either intentionally or unintentionally, the material evidence raised, thereby becoming a co-conspirator due to the neglect to prevent conspiracy in accordance with Title 42 U.S.C. 1986, which states every person who, having knowledge of any of the wrongs conspired to be done and mentioned in the preceding section, and they are about to be committed, and having the power to prevent or aid in the prevention of the commission of the same, neglects or refuses to do so, may be joined as defendants in the action. There is no denying that the judge had knowledge of the crimes which had been and are being committed against the petitioner, as raised in addendums 1 and 2 of the writ of habeas corpus in violation of Title 42 USC 1985b, and despite having the power and duty to act in order to prevent the continued and further commission of the wrongs, the district court judge Thomas O'Rice neglected or chose not to in violation of Title 42 USC 1986. Therefore, as a result of either his complicity, intentional, or complacency, unintentional, the district court judge Thomas O'Rice has become an active participant in the ongoing criminal conspiracy and making his ruling illegal and fraudulent. In accordance with Article 3 of the United States Constitution, judges' roles shall remain in their office while in good behavior. Black's Law Dictionary defines good behavior as the avoidance of criminal behavior. Therefore, the moment that the district court judge chose to engage in criminal behavior, he was no longer fit to continue in his office in accordance with the laws of the United States Constitution and the laws of the United States. In light of this evidence, and as a result of the district court judge's actions and decisions, the criminal conspiracy is no longer confined to the state of Washington and its courts, as the United States District Court is now implicated in the action as a result of the crimes of the district court judge, as clearly evidenced by the record. The United States Circuit Court of Appeals now has original jurisdiction over this matter and not the district court or any court of the state of Washington. Respectfully and peacefully, a servant of justice, Tanawa M. Downing.